Start. When we consider the aforesaid ground taken by the learned single judge to hold that the writ petition was not maintainable, we find ourselves unable to be in agreement with the view taken by the learned single judge. It is tried law that rule of exclusion of jurisdiction of this court under Article 226 of the Constitution of India in the wake of availability of an alternative remedy, be it statutory or otherwise, is not absolute. Article 226 of the Constitution of India is couched in the widest possible term, and unless there is an express bar to its jurisdiction, its power under this article can be exercised when there is any act which is against any provision of law or is violative of constitutional provisions. Reference may be had in this regard to the judgment of Honorable Supreme Court. It is, however, equally well settled that though powers of High Court under Article 226 of the Constitution of India are discretionary and no limits can be placed upon such discretion. Nonetheless, this jurisdiction must be exercised along recognized lines and not arbitrarily. Such jurisdiction is subject to certain self-imposed restrictions. Thus, in appropriate cases, jurisdiction under Article 226 of the Constitution of India is exercisable even in the wake of availability of alternative remedy, statutory or non-statutory. The fine distinction sought to be drawn by learned single judge between these two expressions, with utmost respect, we may say, was unnecessary. Remedy in legal parlance is a mechanism available to an aggrieved person to take recourse to for getting some wrong undone. State for redressal of grievances of its citizenry provides various such mechanisms, remedies. Sometimes a remedy may be provided by way of legislation which will be a statutory mechanism, and sometimes remedy may be provided by a state without framing any legislation or statute, that is by providing simple administrative or executive mechanism. Therefore, in our considered opinion, there does not lie any distinction between statutory or non-statutory or alternative remedies when these remedies are referred to in the context of exercising the discretionary jurisdiction under Article 226 of the Constitution of India by the High Court. Every statutory remedy may be an alternative remedy, and similarly every non-statutory or executive or administrative remedy can also be an alternative remedy, that is to say, a remedy which is alternate to the remedy under Article 226 of the Constitution of India. Learned single judge appears to have ignored the binding precedents. In the case of Sumit Gupta Supra, a division bench of this court considered the provisions of Article 33 of Schedule 1B of the Act vis-a-vis Section 47A and has held that Section 47A comes into play only where the market value of the property in the instrument or the document is disclosed to be lesser than the determined in accordance with the rules. It is in this background that submission on behalf of the appellant petitioner was made that the order under challenge in the writ petition was without jurisdiction, and hence the dictum of Whirlpool Corporation Supra will apply, and as such availability of remedy under Section 56 of the Act will not bar jurisdiction of this court to entertain the petition under Article 226 of the Constitution of India. We may also refer to another division bench judgment of this court in the case of Srimati Vijay Jain versus State of UP and others, 2016. In this case, writ petition was held to be maintainable against an order of collector stamp, notwithstanding availability of statutory remedy under Section 56 of the Act. We also note that in this case as well, learned single judge had refused to entertain the writ petition on the ground of availability of remedy under section 56 of the Act. However, the division bench upturned the judgment of learned single judge and held the writ petition to be maintainable. It is needless to say that division bench judgment was binding upon learned single judge in the instant case as well. Accordingly, the judgment and order dated 25/2/2022 passed by learned single judge in writ C number 1132 of 2022 is set aside and the appeal is allowed. Writ petition shall thus stand restored and shall be decided afresh. We request the learned single judge to expedite the proceedings of the writ petition and decide the same as early as possible. If any application for interim relief has been moved in the writ petition, it shall also be decided with expedition. There shall be